Comiskey. Catherine did.
Ready?
Good to go?
Welcome to the City of Norman City Council Oversight Committee meeting of Thursday, January 12th, 2023. Today we have 3 agenda items, and we're going to start with number 1, discussion regarding the city's role in productive health privacy matters. Have at it.
Or can we start with,
You can start however you want.
What
We have
about
3
the-
items. We can go in any order that you are ready to roll.
I've got the litigation update on
Okay.
first, and that one won't be that difficult to get through. Our office, the city attorney's office by charter, is responsible for representing the city in all litigation. And as a general rule, our litigation, our civil practice encompasses both federal courts and state courts. Of course, in federal courts, the hierarchy is the U.S. Supreme Court. We are in the United States, we're in the Court of Appeals Circuit for the 10th Circuit, which is in Denver. And then our U.S. District Court, where our federal courses originate, would be in the Western District of Oklahoma, which is in Oklahoma City. And then for state courts, we have a bicameral, so to speak, Supreme Court, which is the Oklahoma Supreme Court for civil cases, then the Oklahoma Court of Criminal Appeals for criminal cases. Right below that's the Oklahoma Court of Civil Appeals. And then for our district court cases, the majority of our cases for Cleveland County District Court, we've had to appear in Oklahoma County every once in a while, but that's really very rare. You do have in front of you every month, the legal department does put together and submit a legal department monthly report, and you've got a copy of the report for November 2022. One of the things that I added when I became responsible for producing this report is the very top, it says monthly highlights. If we've got something significant that happens in one of our cases that we've got listed below there, usually we'll put a little blurb in that section, kind of sort of advising counsel of what is going on in that case. Usually, a lot of times, it's maybe we got summary judgment, or we have an appeal that was granted or decided either in our favor or not in our favor. Usually, I'll put something in there just to give you a little bit of an idea. You don't have to necessarily thumb through all of the cases. Most of them are pretty static. They don't really they don't change a lot over time, but again, that's a place that you can look to get an idea as to what's happening in some of our cases. All right, so we're talking about our current pending federal court cases. We do not have any cases pending in the U.S. Supreme Court. We have 2 cases pending in the United States Court of Appeal for the 10th Circuit. The first case is Harmon versus City of Norman. That is a case that involves an alleged First Amendment claim by the plaintiffs who are abortion protesters and who used to protest on the sidewalk in front of Dr. Burns' office, which is just west of Southwest 24th Avenue in Norman. We have actually been up to the 10th Circuit in that case once on the plaintiff's request for a temporary injunction. We prevailed both at the district court level and at the Court of Appeals level. We came back to district court for proceedings on their request for a permanent injunction. We prevailed on those issues. They appealed that, and that case has been fully briefed and is currently in the 10th Circuit waiting on a decision from the 3-judge panel that's assigned that case. The second case we have in the 10th Circuit is Shaw versus City of Norman. That is actually an excessive force case that arises out of a high-speed chase, where unfortunately the person that we were chasing crashed into Mr. Shaw's vehicle. He's alleged excessive force and a number of other federal constitutional claims. We filed a motion to dismiss. That was granted. The plaintiff has appealed the district court's decision granting our motion to dismiss. I got notice yesterday that that case is set for oral argument on March 21st of this year, so we'll be going up back to Denver.
So that's one, you briefed us on it before. We've had that, but I don't know if that was in executive session, right?
I don't think we've talked about Shaw in executive session.
There was one that
I agree with you.
yeah, that they were going and they were blaming us for the high-speed chase because the guy wrecked into it. Was that a different one?
No, this must be that one.
Okay.
I guess I'm going to say that the plaintiff must have made a.
It wasn't at the Court of Appeals at that time, I don't think. It was in
negotiation.
Oklahoma
Yeah.
or something.
This case is a little screwy.
That wasn't even that long ago.
Well, and you'll see why in a second, and here's why.
Last fall.
Yeah, the procedural posture of this case is, The plaintiff filed their case in state court and never served it on the city. It pended for a year, and finally, the state district court sends what's called a notice of disposition docket, which essentially says, show up and tell us why you haven't proceeded with your case, because if you don't, we're going to dismiss it. So the plaintiff's attorney showed up at the disposition docket in state court and said, go ahead and dismiss it, because I'm going to refile it in federal court. So it gets dismissed in state court, it gets refiled in federal court. In federal court, we file a motion to dismiss, it gets granted, and the petition includes federal claims, and then it includes one state law claim for negligence. So the federal district court granted our motion to dismiss the federal claims with prejudice, and then dismissed the state law claim without prejudice, essentially declining to exercise jurisdiction over the state law claim. And federal courts have the ability, they've got discretion, if they don't want to exercise jurisdiction over a state law claim, they don't have to. And generally, if the federal district court dismisses all the federal claims and then there's one state law claim pending, more likely than not, they're going to refuse to exercise jurisdiction and dismiss it, and then the plaintiff can go refile it in state court if they have that ability. So what happens here is, after the federal court issues its order, the plaintiff appeals the federal district court's rulings, and then comes back down to state district court and files another case for negligence under state law. All right. Under Oklahoma law, it's in Title 12, I think it's Section 100, it's called what's called a saving statute. If you file a case within the statute of limitations and it gets dismissed for some reason other than on the merits, if the statute of limitations is run, the saving statute gives you a year to refile that case. But you can only refile it once. And that includes filing it in federal court. So in the Shaw case, you filed it in state court, it got dismissed. You refiled it in federal court, it got dismissed. You try to refile it in state court again, our argument is, time out, you've already had your one chance. You refiled it in federal court already. That was your one chance under the saving statute to refile your case. You've already exhausted that, so your state court case should also be dismissed. If we jump forward to our cases, and these are the state law cases that we have pending. This case right here is pending in the Court of Civil Appeals. This is the second refiling of the case that was originally filed in state court, refiled in federal court, now refiled in state court again. In the district court level, we moved to dismiss, arguing you've already exhausted your one refiling. The district court granted our motion, and the plaintiff has now appealed this case in state court. So we really have two cases.
Holy moly. All right, so I don't,
You're going back to Denver?
Yes.
Me, I'll just tell you, having input on that right now, I would say that y'all need to work on that a little bit, and then you're good luck.
And be careful about talking about recommendations in these cases, because
Yeah.
yeah,
do that.
I'll tell you what we're doing here is if there's any of these that y'all say that y'all want to bring to executive session, that's what we're going to do. And that's all I'm doing is if we might be able to clean up some stuff, that's it. I'm not, y'all look at these and if y'all pick some that y'all want to look at, that one, I don't even want to hear any more about it till it's done.
So
That's my opinion.
we're working our way through that one. And currently in the Western District, our federal cases, we have two. Thompson versus Board of County Commissioners is what I would call the Cassie case. If you remember, it was the gentleman out at the hospital, was having some issues, either medical or mental, that we ended up dragging, ultimately taken to jail. He did pass away when he was in jail. The issue in this case is the plaintiff sued 10 to 15 defendants, and the summary judgment deadline was a year and a half ago, so when the summary judgment deadline came along, he got 10 to 15 motions for summary judgment. My recollection of the district court's order was at the time that it entered its order, kind of advising the parties as to what was going on, there were 63 motions pending.
Wow.
So the court's having difficulty, obviously, working its way through all these motions. Some of the defendants have settled with the plaintiff since then. We have not. We have 2 individual officers that were sued. They have not. I don't believe the county has. I know the hospital has. He sued the ER doctors. I believe they've settled. I know the hospital has settled. But we're just waiting we did talk about this case in executive session, and sort of the guidance given there was just wait to see what happens on summary judgment, and then maybe we'll bring this case back for executive session after the court rules on those motions and go from there. Smith versus City of Norman is a fairly new case. It's an alleged pregnancy discrimination case. We did talk about this case in executive session. There was a settlement offer made by the plaintiff. Ultimately, we decided the guidance was that no, there really wasn't any interest in paying her what she was demanding, so we'll just move forward with this case. We have filed a motion to dismiss one of the plaintiff's claims in that case, and that is just outstanding, and we'll see what happens once we get there. All right. Our state court cases. We have one case that we're kind of sort of a participant in the Oklahoma Supreme Court case, and of course that's the case regarding the proposed turnpike in East Norman, Cleveland County. We are just waiting for that issue that was raised by the OTA. Been fully briefed. There was a hearing before the referee. There was a hearing before the Supreme Court, and we're just waiting for a decision in that particular case. Don't have any cases pending before the Court of Criminal Appeals right now. Again, the Court of Civil Appeals, we have the one case, which is the Shaw refiling of the case in state court after it got dismissed in federal court. Cleveland County District Court, we have 14 active, I'm going to say 14 civil cases. One is Walling versus Norman Regional Health System and others. That is an issue about Norman Regional Hospital's billing when someone is taken for a blood draw. The plaintiff is arguing that they're being charged for the cost of the blood draw. We're arguing no, they're not. That case was filed in 2014. Actually, the court ruled in our favor and then reversed herself, and then we're just on the issue of class certification. That's an issue that's immediately appealable. We have not done a journal entry in that case yet, and I think once we do the journal entry, that'll start the time to run for appealing, and my understanding is Norman Regional wants to appeal her ruling on that issue, so we're just waiting to see what happens when we get the journal entry. McCarver versus City of Norman is a 2013 case about excessive force. It's about a vascular neck restraint that was used to get someone who was in the ER, was combative, and apparently once we did the vascular neck restraint, shortly after that he went into cardiac arrest. The case, the way that it was filed was indicating he had some permanent injuries, and it was filed in 2013, and the court put it on its disposition docket in 2015. The plaintiff said they wanted a scheduling order, but they've never sort of pursued one. In this case, it's just been languishing out there since 2015.
Pardon me, is that the new preferred vernacular?
What?
What'd you call it?
Vascular hold.
Vascular.
Neck restraint, yes.
Okay.
And my understanding is the difference is the vascular neck restraint is supposed to put pressure on your artery, not your windpipe. And if it slows the blood flow down, that's supposed to cause you to pass out as opposed to choking you in. Over the years, when I look at this case, I found Mr. McCarver's profile on Facebook. It appears he's moved to Tulsa. And at least the stuff that I can see on Facebook doesn't indicate to me that he has any sort of permanent injury. So maybe his attorney has lost interest. They just haven't really pursued anything after they requested a scheduling order in 2015. Fulton versus Wright et al. Is a automobile motorcycle wreck case that occurred in northeast Norman on North 48th Avenue. Essentially, a semi was pulling out from a neighborhood, and Mr. Fulton was on his motorcycle, apparently didn't see him, crashed into the semi truck, apparently had some fairly significant injuries. My understanding is that Mr. Reich's insurance company is settled with Mr. Fulton, and we filed a motion to dismiss, really haven't heard anything from them since then. It's been pending for quite some time, and I'm not sure, maybe they lost interest, I don't know, with regard to that particular case. City of Norman versus Lonnie Hodges involves illegal dumping into the Canadian River watershed. We met with Mr. Hodges' attorney. He has agreed that he will not dump any further. I think he was allowing remember the case when the university was building the stadium and they were taking a lot of stuff out to the river and dumping it? I think that was on Mr. Hodges' property. He's agreed that he wouldn't do that anymore, and we talked about going out and doing an inspection to ensure that. We just have not gotten around to doing that yet, but assuming that he is abiding by what he told us, we probably will dismiss that case once we can verify whether or not he's actually stopped doing that. Eder versus City of Norman is a negligence case. It's an auto pedestrian accident that occurred on the southwest corner of the intersection of Main and Southwest 24th Avenue. The fact pattern is really unusual because it's not really clear how Miss Eder was hit by our truck. She claims that it had been hit by the trailer. She was on one of the motorized scooters. She had made a 911 call because she claimed that someone in Aldi was stealing stuff, but the thief person ran out and she followed him on her scooter, and I think she was paying attention to the thief person and not paying attention to the traffic, and the possibility exists that she ran into the back of our truck. Our truck was pulling a trailer, and she ran into the back end of the trailer, which causes me to go, if the trailer was in the intersection first and you ran into it, I'm not sure how we're liable, but we've done a little bit of discovery in that case, and those plaintiffs' attorneys have not really been that active with regard to pursuing that particular case. Flores versus City of Norman is a personal injury case, and the allegation is that the plaintiff was unloading yard waste at the transfer station and claims to have been hit in the head by the front loader that staff uses to load the semi-truck with the trash to take to the landfill. The problem with that case is we did some discovery, one of the allegations is that the plaintiff sustained a traumatic brain injury. We did some discovery, asked to give us the names of the medical providers, asked for a medical release. For the medical care providers, he put Norman Regional Porter Campus and the Healthplex, and that's it. We sent a records request to Norman Regional Health System, and they said we do not have any records for him at all.
Oh, wow.
I got a call a week or so ago from the plaintiff's attorney saying, hey, maybe we can solve this case. I said, well, you're going to have to give me some information and convince 5 council members that they should pay your client some money. And right now, I don't have any medical records showing that your client was injured. And he said, well, let me look and see what I can find. And ultimately, he came back and said, I can't find anything either. Maybe you got a bill or something that would give you an idea as to where he received medical treatment. And I said, well, get that to me and we'll look at it and go from there. We even went to the extent of the immediate care that's in the Healthplex sort of general area. We thought that, well, maybe some people get confused and they go to the Healthplex, or maybe they go to the immediate care and they think that that's the Healthplex. We sent our records request to them, and they also said we don't have any records with regard to this person either. So on that one, we're sort of in a holding pattern, waiting for the plaintiff to get us something that indicates that his client was actually injured. Easley versus City of Norman, actually this is a 2022 case, but this started in 2012, and it has to do with changing windows on a house in a historic district without getting a certificate of compliance. We've been up to the Supreme Court and back once. We're now, the first case told us to go to the Board of Adjustment. We did. The Board of Adjustment denied the certificate. That got appealed to district court, but it wasn't timely. We moved to dismiss. It got granted. That went to the Supreme Court. The district court ruling got affirmed. We came back for another application before the Board of Adjustment. Same result. It got denied. I think this was just another attempt to try to see if they could make the deadline or the statute of limitations for actually filing their appeal. They filed it, and we just need to go forward with filing a motion for summary judgment to get that case off high center and moving on down the road. Jacobs versus City of Norman is a sewer backup case. Miss Jacobs' house is just north of Wilson Elementary School. She had a sewer backup in her basement. She believes that it's a result of some negligence on our part. We've been out there. We have not found anything that would have caused her sewer to back up based on maintenance of the city sewer main. Part of the issue in her case is her house shares a lateral line with the house to the south, with her house being at the higher elevation and her neighbor's house being at the lower elevation. And the issue being, if there was a backup in the sewer main, our neighbor's house would have flooded first because it's at the lower elevation with regard to that lateral line. They were pretty aggressive with regard to their scheduling order and ultimately had to back off of that a little bit. I've talked to them about the possibility of us coming out and doing a TV camera inspection of their lateral line. I drove by there and noticed that on that side of the house, there are a lot of trees in that area, so the possibility exists that it could be roots that are clogging up the lateral line that's causing her basement to flood as opposed to something in our sewer main. We talked about that. We're going to try to see if we can get that scheduled as soon as I can find an expert that maybe to help us a little bit to figure out what we need to be looking at. Shaz Investment Group LLC is the Eagle Cliff case, and I'm sure you guys know all about that. We have filed a motion for summary judgment. They filed a response. The hearing is February 23rd, so we'll just wait to see what happens when we take that summary judgment motion before Judge Falkman. The Hunter Miller case is the issue about the request for a zoning change at the intersection of Berry and Flood.
No, or
Berry
board.
and Lindsay.
Lindsay, yeah.
Yeah, Barry and Lindsay. And, we've talked about doing some mediation to see if we can get that resolved. I got a call, it's December before Christmas, from somebody in Dallas who was asking about this particular piece of property. And it sounded as if this person had a buyer that was considering maybe purchasing it and just using the commercial part of that property or that lot and putting in, something, he said some kind of drive-through. He didn't really give me any specifics, but it sounded as if he did not intend to request a zoning change. For whatever it is that they were thinking about proposing, it would have not required a zoning change.
Isn't it, but it's office. It's not,
CO.
right.
But whatever it was, whatever we were talking about, and again, he wasn't super specific, but it didn't sound like it would have required a zoning change. I don't know, it may have, but at a minimum, it would have been a zoning change on that one lot that's actually on the corner as opposed to the one residential. It didn't sound like he was proposing purchasing the lot that's on residential. So we'll see how that goes. West Lindsay Center Investment LLC is a case that arises out of a sewer backup that's alleged to have been caused during the streetscape renovation of West Lindsay. The allegation is, I guess, whenever the plumber who was connecting the sewer lateral line to the sewer main during that project didn't actually connect it to the sewer main, sewage backed up in the pipe and then ended up backing up into the West Lindsay Center. That plaintiff has sued us and two of the contractors. The problem with their case against us is I think they didn't file it timely. I think it got filed beyond the statute of limitations, so we have filed a motion to dismiss that case based on filing within the statute of limitation, but that was just filed maybe a week or so ago and they haven't responded yet. And I haven't set it for hearing. I was going to wait to see what their response is like before making a decision with regard to when to set it for hearing. City of Norman versus Legacy Property Partners is actually a zoning case that we filed, and this was sort of the first, this was before we had our Airbnb ordinance or short-term rental ordinance had been enacted. This was actually the first one that we had difficulty with. They actually agreed to a temporary injunction and have never really come back and argued that it should be, the case should be dismissed. Based on the fact that we do not have a short-term rental ordinance, that case and that injunction probably can be dismissed. It's just, I don't know why the plaintiffs or the defendants haven't come in and requested that yet. They may not be operating a short-term rental anymore.
Can't you just dismiss it if it's
Yeah.
pointless now? All you gotta do is put it in motion.
Yeah.
There you go.
Well, you could,
If it was us that filed it against them, all you have to do is put it in the motion, dismiss, the case is over.
trying to think, they haven't filed you can dismiss without leave of the court if they haven't filed a responsive pleading. I'd have to go back and see if they filed a responsive pleading yet. I don't think they have, but I can't imagine that if we went to them and said, hey, do you care if we dismissed? I'm sure they're gonna say, no, we don't care.
Yeah.
I mean, you would just put in there that the other party doesn't object to it.
It's clearing space on paper at that point.
Mortgage Clearing Corporation is a foreclosure action where we are owed about, in that, we have liens in that case for some code compliance abatement, and then I think there maybe is a water bill that we're claiming that we have liens or an interest with regard to that foreclosure. And the same is true for the second one. I mean, we have CDBG funds that are outstanding in the amount of about $3,000. And I believe both of those, there was some, I know the second one, there was a motion by the plaintiff asking for a stay because they believed that they were going to work out some resolution with the defendant. The same may be true for the second one, but not, in both cases, a final order of judgment has not been entered, so we have not recovered our funds, and we're just waiting to see how that case gets resolved with regard to the foreclosure by the mortgage company. All right. We have 7 condemnation cases that are pending. And the Chastain Oil Company case, I mean, in a condemnation case, what happens is a lot of times we need the property in order to move forward with the project. We'll try to negotiate a settlement with them. If we can't negotiate a settlement, a lot of times there's a time limitation on funds that we can access, but we have to start the program at a certain time. So if we can't come to a negotiated agreement, we'll file a condemnation action. When that happens, the court will appoint commissioners. The commissioners will do an appraisal. Once they do their appraisal, we deposit the appraisal amount in court, then we can have possession of the property. And then we'll again still negotiate with that particular property owner to try to come to some resolution. A lot of times in order to preserve their right to a jury trial on the issue of damages, the defendant will essentially file an objection to the commissioner's report and a demand for jury trial. But to have an actual jury trial, you have to file what's called a motion to enter. And a lot of times, like in some of these cases, the defendant has just really never asked for a motion to enter, so there's sort of in that limbo phase where a demand for jury trial has been made, but nobody's filed a motion to enter. We probably have deposited the commissioner's award in court and have taken possession of the property and possibly even finished the project, and you're just waiting to see what's going to happen in terms of the defendant wanting to move forward with their request for a jury trial. That's the case both on the Chastain case, the West Lindsay Center Investors case, which are both 2015 cases that arise out of the West Lindsay Streetscape project. And Teetsort, they actually demanded a jury trial, but they have already withdrawn the funds from the court. They did that on December 19th, but just haven't come back and said, hey, you know what, we think we're fine. We're not going to move forward with a demand for jury trial. We're happy with what we've received. Sometimes that's the result of, actually, in Teetsort, that defendant's attorney is one of our former city attorneys, Mr. Blaine Nice, and I think Blaine's just having difficulty with his client, and it's kind of one of those deals where you don't want to prejudice any of their rights just in case they come back at some later point in time and say, why did you do that? So that's sort of why Blaine's been a little bit reluctant to move forward on that one, because he isn't sure what his client wants to do. Apex Property, again, that one's fairly recent. There's a demand for a jury trial that was filed on September 16, 2021, but no motion to enter. The same is true for the Uplands case. Actually, the Uplands case and the Hallbrook development case have a little bit of a twist.
We were briefed on those on Tuesday.
So you know that the hearing on those motions to stay or the motion to disperse fund is February 6th of 2023. So we'll have to see what happens in those two cases. And then the D&J land case, again, they filed a demand for jury trial, then an amended demand for jury trial, but have yet to file a motion to enter those cases on the jury trial docket. Any questions about any of our cases that we have?
Have at it. Councilman Holman.
I didn't see are the Park Drive and the Flesky cases resolved entirely now?
Yes.
They are.
Yes. So
We won both of them?
Yeah, you're talking about the Flesky cases over on Northwest 36th Avenue. That was a request for a zoning change. And then is it Golden Tribe? Golden Tribe was over here by Andrews Park, and both of those cases, well, let's remember. In Golden Tribe, we won at the trial court level, and the Court of Appeals affirmed if there was a petition for cert, it got denied, and and the mandate was issued, so that made the case final. In the Flesky case, the district court ruled in the plaintiff's favor. We appealed it. The Court of Civil Appeals reversed. Either there was no petition for cert or it was denied. The mandate was issued, making that case final. So those two cases are final. And I haven't heard anything since then with regard to those particular parcels.
Those were both cases where we denied zoning changes and we were sued and
Right.
came out in our favor.
Great.
All right. All right. City's role in health privacy matters. My understanding is that this issue was identified by council as a priority during the 2022 retreat. Staff was provided with a proposed reproductive health resolution that appears to have been drafted in response to the Supreme Court's decision to reverse Roe v. Wade. In that case is Dobbs versus Jackson Women's Health Organization, which is a 2022 U.S. Supreme Court case. The operative sections of that resolution sort of had two different types of ways to approach this. One has to do with prohibiting the use of funds or public funds to store or catalog any report of an abortion, miscarriage, or other reproductive health care act, to prohibits providing information to any other governmental body or agency about any abortion, miscarriage, or other reproductive health care act issue. It also prohibits use of public funds for conducting surveillance or collect information related to an individual organization for the purpose of determining whether an abortion has occurred, except for, of course, aggregate data that did not have any personally identifying information on it. The second sort of approach with regard to that resolution was to direct law enforcement to give potential criminal cases that may involve abortion the lowest priority for enforcement, except where coercion or force is used against the pregnant person, if there's criminally negligent conduct involving health of the pregnant person seeking care, or where the abortion or miscarriage or reproductive health care is not the crime being investigated but evidence of another crime. Kind of sort of looking at Oklahoma law in terms of what happened after the Supreme Court issued its opinion in Dobbs. There are at least 4 provisions. House Bill 1904 amended the provision in Title 63 regarding who could perform an abortion. And now to perform an abortion, you have to be board certified in obstetrics and gynecology. And any person who performs abortion that's not board certified in obstetrics and gynecology is guilty of a felony, punishable by imprisonment of not less than 1 year or more than 3 years in the custody of the Department of Correction. House Bill 2441 talks about a detectable heartbeat, and essentially that provision requires before there's an abortion, there has to be a procedure done to try to detect whether or not the unborn child has a heartbeat. If you don't do that, you're guilty. If you don't do that and you perform an abortion, you'd be guilty of a homicide under the provision. It's codified in Title 63. Senate Bill 612 is the provision that defines when an abortion can be performed. The first part of that talks about the definitions of abortion and unborn child. It uses the same meanings as in 63 OS section 1-730. It goes on to say, notwithstanding any other provisions of law, a person shall not be purposely perform or attempt to perform an abortion except to save the life of a pregnant woman in a medical emergency. And then, of course, the definitions that's used in that particular provision are set forth in, like I said, section 1-730 A1 and A4. Of particular significance, the definition of unborn child means the unborn offspring of human beings from the moment of conception. So there is no exception with regard to race or incest, and there is not the trimester or the viability determination that used to be sort of what Roe versus Wade was based on, primarily on the issue of viability. So under Oklahoma law, under this provision, the only time an abortion is appropriate is to save the life of a pregnant woman in a medical emergency. I did visit with Councilmember Grant. She talked a little bit about the civil provisions. I think the reason I missed this is because I was focusing more on criminal stuff. There was Senate Bill 1503, and it codifies the Oklahoma Heartbeat Act. It allows any person other than the state or political subdivision or employee of a state or local government entity in the state could bring a civil action against a person who performs or reduces an abortion, knowingly engages in conduct that aids or abets in the performance or inducement of an abortion, or intends to engage in the conduct prescribed by paragraphs 1 or 2 above. And so this provision allows a non-governmental entity to bring a civil action against someone for one of those, for engaging or attempting to engage in the inducement of an abortion. But again, that's enforced exclusively through private civil action, and as a general rule, probably would not have any impact on law enforcement. So we talked about these two issues in terms of the first issue with regard to use of city funds, and then we also talked about the issue of placing limitations on law enforcement. The resolution as written has a sort of disclaimer on the issue of use of city funds, and it talks about the policy stated above does not apply in cases where coercion or force is alleged to have been used against a pregnant person, or in cases involving allegation of conduct criminally negligent to the health of the pregnant person in seeking care, or where the abortion, miscarriage, or reproductive health care is not the crime being investigated, but another evidence of the crime. And the difficulty that we were having when we were discussing this is I'm not clear, or it's not clear if this exception would allow investigation into someone who's performing an abortion who's not board certified, as required by the amendment in whichever House bill it was. Because I probably would characterize that to be more than criminally negligent. It's more intentional. And if we couldn't use city funds for the purpose of doing those types of investigations, I think that's a big problem. I mean, if you had someone who wasn't certified, board certified, that was engaging or providing abortions for people, this would appear to say we couldn't use any city funds to investigate that type of a crime.
Right.
Is it clear what entity is supposed to enforce this? As it doesn't seem like a local police matter. It seems more like a state, like FBI or state police. I don't know who would be in charge of keeping track of this statewide like this.
FBI's federal, so they wouldn't have any.
Well, I mean like the
OSBI.
OSBI, I should say.
OSBI is a secondary law enforcement entity. And what I mean by that is OSBI doesn't come in unless the local law enforcement entity having jurisdiction asks them to come in. They have primary jurisdiction over some offenses, but just general criminal offenses, they don't really have primary jurisdiction over. So it really comes down to what's being reported and where is it being reported. Sometimes when someone comes over to the police department and wants to make a report, sometimes those reports can be investigated by our officers, and sometimes if our officers don't have jurisdiction, they would have to be referred to some other law enforcement agency. So in terms of whether or not there's any specifics in the statutes about who's responsible for enforcing these, no, there isn't. They're just like any other general criminal statute that maybe local law enforcement investigates it. In this case, because
If it's like a doctor performing it, it seems like that would be like a board cert. Like,
well, the board
however they enforce other regulations on doctors doing other things that they aren't allowed to.
It would be administrative. I mean, the example would be if you're performing some procedure you're not licensed to perform, the State Board of Medical Licensure can pull your license to practice medicine.
Now you're also committing a criminal act in the state,
Right, so
as a state.
there could be both.
Right.
I mean, and a lot of times there probably would be both. More likely than not, if you're convicted of some criminal offense that involves, some medical procedure that you weren't supposed to perform, you're probably going to get your license revoked, and you probably can be convicted criminally. So that possibility exists that you could do both. But there's nothing specifically with regard to what a specific law enforcement agency being authorized exclusively to investigate these types of offenses.
But you're also saying it's unclear if we, city police, even have the authority to? Is that what that second part's saying? That bullet?
No, here's what I'm saying. What I'm saying is, this is language from a proposed resolution. I mean, the resolution that we were provided, it had Tulsa on it, but Catherine called Tulsa and wasn't able to find anybody there who knew about it. She did find a similar version from Athens, Ohio. And the issue is this. So the approach of this resolution is to say, okay, law enforcement can't use public funds to, let's go back. Law enforcement, the operative part of this resolution, law enforcement can't use public funds to store or catalog any report of an abortion, miscarriage, or other reproductive health care act. So you can't store any information about abortion, miscarriage, or any other reproductive health care act issue. You can't provide information to any other governmental body or agency about abortion, miscarriage, or other reproductive health care act. And you also can't conduct surveillance or collect any information related to an individual organization for the purpose of determining whether an abortion has occurred, except for aggregated data, without personally identifying information. So this resolution would say you can't spend any public funds, the police department couldn't spend any public funds for those three, in those three areas. And the question becomes, okay, if we did that, if we enacted this resolution as written, and a doctor performs an illegal abortion, and the victim comes in and says, I had an abortion from this doctor, he wasn't board certified, under this provision of state law, that's a crime. If the police department can't store any information, if they can't provide any information to other governmental bodies, if they can't conduct surveillance, what do we tell that victim?
Do we currently store healthcare information? Like, does Norman PD currently do that for any other group of people? And does Norman PD currently share healthcare private information with other departments? Because I don't want to create a thing where we've singled out a specific group that Norman PD is enforcing something against.
If someone came in and wanted a report about somebody committing a crime, and it had part of the information submitted, or one of the elements of that crime involved healthcare information, yeah, we would take that report. And it would be stored in LARMS, our Law Enforcement Management Record System. So I'm trying to think of another offense where healthcare information would be at issue. Let's say it was, somebody was alleged to be abusing somebody that were elderly, and it had something to do with healthcare, and they came and said, this is what's going on, and it involved that person's healthcare information. Yeah, we would take that report. If we needed to share that information with DHS, their Adult Protective Services Unit, yeah, we would share that. So, again, that information would be shared in other instances, and the difficulty with this language is it's broad enough to where I would be hesitant to recommend approving it, because it seemed that it would prohibit law enforcement from investigating instances where people were committing abortions that were not legal, that were not lawful. And that's the difficulty with that as written.
But it's also moot right now, right? Because there are no abortion providers in Norman that I know of. Then the one clinic.
Well, Dr. Burns is closed. I mean, this would, what lawyers do is we sit around and try to think up scenarios about what would happen if this happened, or what would happen if that happened. I mean, this would really come into play is, it would come into play if you had somebody who wasn't board certified, who performed an abortion under circumstances where it wasn't medically necessary to save the person's life.
Go ahead.
I have a question. So let's just say somebody legitimately had a miscarriage or whatever, but they were going to an ER or whatever, and the person there felt that it wasn't a miscarriage and that was a failed abortion. Like, what's the gray area around there?
Well, the area around there the area in that case really has more to do with HIPAA regulation than really these particular provisions. Because under HIPAA, that healthcare provider is not allowed to disclose that information without your permission, without the patient's permission. When I was looking at this issue, there is a Federal Department of Health and Human Services document that talks about instances when healthcare providers can release your information, and most of the time it's discretionary, or at a minimum, it requires consent of the patient before you can release that information. So the question would be, under those circumstances, I suspect it's a possible HIPAA violation for that healthcare provider, without the consent of the patient, to go tell law enforcement that I believe this person had an abortion. But even if that happened, these provisions under state law impose potential criminal sanctions on the healthcare provider, not the patient. So, I mean,
I guess it's the civil part, huh? If somebody wanted to make it a problem for them that way.
yeah, and going back to the civil part that we talked about. The civil part is an action against somebody who performs or reduces an abortion, knowingly engages in the conduct or aids and abets the performance or reducing of an abortion, intends to engage in the conduct described in paragraphs 1 or 2. So that really is still focused on the healthcare provider, not the patient, or not the pregnant woman. It's focused on the healthcare provider. So yeah, the difficulty comes in, and when you're talking about the issue being moot, it has to do with, it's really focused on the healthcare provider, but the way that this is written would appear to, if the patient wanted to come in and make a complaint, that the PD would be prohibited or precluded from taking that report, because they wouldn't be allowed to store or catalog any report of an abortion or miscarriage or other reproductive health care act. They wouldn't be allowed to provide a governmental agency if they thought that maybe we shouldn't be investigating this, maybe it should be the State Board of Medical Licensure. They would be prohibited from providing that information to that administrative body. And then, if the need came that they needed more information, that they needed to conduct some surveillance to find out or flesh out a little bit more about the victim's report, they would be prohibited from doing that also.
Could a healthcare provider, in theory, who is handling an emergency, and let's say it's like ectopic pregnancy that's ruptured.
Okay, I found this on the web for who is handling it.
But, so let's say you have somebody who's actually not an OBGYN doing a life-saving procedure that results, like, an ectopic pregnancy is not viable, but, say somebody in their family was upset by this and wanted to turn that healthcare provider in.
I mean, the issue is people come to the police department and ask to make reports about stuff that's not a crime every day. Usually what happens is, in most cases, the PD is going to take the report. They're going to run it by somebody in the DA's office, and the person in the DA's office, if it's not a crime, is going to say, there's nothing we can do with this, it's not a crime. So under those circumstances, if it were truly a case where an abortion was performed by a board-certified obstetrician or gynecologist, and it was lawful under Oklahoma law, but somebody thinks it wasn't or wants to come in and make a report, you're probably going to take the report, but it's probably not going to go anywhere, because ultimately, I think the information is going to show that it wasn't a violation of Oklahoma law.
Mr. Chair.
Okay, yes, ma'am.
So my questions just relate to, have any charges been filed or any civil cases filed under this new law
Not that I know of.
yet in Oklahoma?
It's possible.
I know there's a similar law in Texas and there have been, but
It's that salt law, I'm pretty sure.
But it's, I mean,
I
something.
think they
could-
just copied it.
right, yeah.
Something could be depending at the district court level that we just don't know about. I mean, it's kind of like some of these cases that we went through. Those cases have been there, they're dormant, yeah, it's pending, but you wouldn't know about it unless you were a party or unless you really, really
Yeah.
did a lot of research to figure it out. So
Yeah.
are there any reported or unreported appellate court decisions about these particular statutory enactments? No, there's not.
Okay. The reason I asked was just so, if something is working through, that becomes a precedent, then we can gather more information about how this is actually being used legally in the system.
That would be-
And then we would have more information to kind of go off of and how this would affect and like what the court is going to say and how they try these cases.
I think that approach is probably the most prudent. In other words, instead of jumping out and enacting a resolution that may have a bunch of unintended consequences that we really haven't.
So my other
Figure out.
question is, this statement at the top here is like proposed language that we could look into to adopting?
Right.
Okay.
That's what that is. This is language from the proposed resolution that we got.
Okay.
That again, and Catherine found a very, very similar version out of Athens, Ohio. And quite frankly, we don't have any information that indicates that a municipality has actually adopted this resolution.
It wouldn't seem necessary to me if there's state law that already covers something, why do anything about it at our level? We can't affect state law and we can't have law that supersedes state law. So why take action?
That's a good question. I mean, your statement is correct. I mean, we don't have the ability. Number one, in terms of our ordinances, in terms of criminalizing conduct, we don't have the ability to criminalize behavior in our ordinance that's a felony under state law. And each of these offenses in those new criminal provisions are all felonies. And then again, like I said, there's the civil one, but there's nothing we can really do about the civil one because more likely than not, even if you had this resolution limiting, how city funds could be used, the civil litigation is not going to go through the police department. The civil litigation is going to go through some civil process that we don't have the ability to control or impact.
Go ahead.
So, does our civil law have the same bounty award,
Yes,
the $10,000?
it does.
Okay. Is there any litigation involving that currently?
I haven't seen any, and I know that there were some challenges to Texas's scheme that worked its way through the federal court system.
Like the government offering citizens money to like tell on their neighbors is kind of concerning to me.
Yeah.
In regard to, really anything. But with this law, are we in a situation where like a neighbor could call Norman PD and say, I think my neighbor had an abortion, and Norman PD is going to have to go to that person's house and say, we got a call that you might have had an abortion. Is that a scenario? Because
I almost view that question, and of course, if you're an attorney and you have family
like you
members-
said, people call 911 for anything. They call for things that aren't illegal.
If you're an attorney and you have family members, they're always going to come ask you is, can I sue somebody for this? And the answer is you can sue anybody for anything. The question isn't whether you can sue that you can recover. And a lot of times, based on what you're saying, that answer is probably not. The same is true there. Anybody can call the police department and allege anything they want.
Right.
This
But
one's,
usually, and what was going through my head and what I talked with Councilmember Grant about yesterday was a lot of times you're going to want those allegations to be based on personal knowledge, not I think that something may have happened. It's like, well, you really don't have any personal knowledge of whether this happened or not. And yeah, maybe we'll take a report and we'll keep it in our officer information section only, but you're probably not going to spend a lot of resources trying to investigate something when the information that you're getting on the front end is just speculation or conjecture.
I mean, I guess there's thousands, tens of thousands of births in Norman a year.
Oh, yeah, probably, yeah.
I mean, do you know any, I'm sorry.
No, please, yeah.
Do you know any other thing, statute that allows an uninterested third party to bring suits like this? Is there something?
Well, I guess the question becomes on how do you define interested party?
Uninterested.
What goes through my
This
head
is-
I mean,
this
it's
is
like-
anybody.
It's kind of like the key tam lawsuits. I mean, a key tam lawsuit is if 10 taxpayers believe that the municipality has spent money illegally, they can get together and send a demand and say, either go pursue that money, or if you don't, we will. So it's somewhat similar to that. We've had one key tam lawsuit since I've been here, and it sort of fizzled away. But this is somewhat similar to that, but it kind of sort of really goes back to the threshold question of, for pleading purposes, you have to be able to at least push the ball from speculation and conjecture to, there's some reasonable probability that this happened, and under this set of circumstances, what's your evidence? What are you going to?
You'd have to have one eyewitness or someone close to it.
What's gonna be your allegations in your petition to show that there's evidence out there to support what I'm alleging? Haven't really done any research for
See how it
Texas
goes, I
stuff,
guess.
but yeah.
I was gonna say, I can see an interested party if somebody, because like we're talking about the civil part, I don't know how it would work for like a criminal one, but let's say someone in a relationship, there's domestic abuse, gets pregnant, leaves the state with the help of their friends, and comes back, but that partner, whether they're part of the picture or not, decides that, they have feelings about it and decides to press either civilly, or could they ask for investigation at that point?
Well, Oklahoma's jurisdiction is limited to our state boundaries. So if somebody goes and gets an abortion in another state, we don't have jurisdiction over that. And again, these statutes are focused on the abortion provider, not the victim. So under that facts pattern, we don't have the ability to go prosecute a doctor in another state under these provisions.
Well, pardon me, and there's something, I know they've been kicking it around to make it aiding and abetting, where they'll charge you if you help somebody go out of state to perform this. And I don't know how that'll hold up, but I know that that's been kicked around.
That's been kicked around, and I think that's a little bit of the concern, but it kind of sort of goes back to the issue of, I don't know if there's anything that we could do to prevent that. I mean,
Is the we the state or is the we the municipality?
It's the what?
Is the we the state in your statement? Is the we the state?
we is the city.
The city, okay,
Yeah,
yeah.
I mean, that's, there are probably gonna be there are some federal constitutional prohibitions with regard to extrajudicial enforcement, so on and so forth. So if that occurs, the defense is probably gonna come from those types of issues, and the prosecution is not gonna be initiated by us. Even the investigation probably wouldn't be by us. It's gonna be by some other law enforcement entity. Making those factual allegations, I mean, the difficulty, how do you investigate that?
Let's,
If you go to I'm a Norman Police Department officer, I go to Kansas to interview a doctor that performed an abortion, the doctor's gonna say, I don't have to talk to you. And you don't really have, from the personal jurisdiction perspective, for civil cases, I don't have personal jurisdiction over an entity unless they are in the state. Now, there are some other theories. A lot of times it has to do with advertising. If you advertise heavily in the state, you're considered to be a resident, so on and so forth. But for criminal purposes, if you're not in the state, how do we have criminal jurisdiction over you? And if Kansas allows abortion, then Oklahoma doesn't, and we try to prosecute a Kansas doctor, they're going to have to extradite him. Our governor's going to have to send an extradition request to their governor. And if they allow abortions and we don't, how likely is it that they're going to say, yeah, we're going to extradite this doctor to you to be prosecuted
For doing something that's legal where he is.
Right.
so basically, is there any role for municipal government in any of this? That's basically what we're getting down to. I would think, like, is there anything for us to do at all as a municipal government in this area? Or are we just roll with state law and that's what it is?
Well, anything we do probably is going to be more symbolic than anything. Because again, obviously, we don't have the ability to change the state statutes. You could you could try to place limits on the use of municipal funds, but again, the issue that we're having here that we're talking about is there's a lot of unintended consequences. We may be, hamstringing ourselves with regard to certain prosecutions for people that are victimized. And I'm not sure of how you would draft language to resolve that issue. And again, there are probably going to be instances where it would be totally appropriate for us to store that information, to pass it along to another governmental entity, and to possibly do some surveillance. And if we hamstring ourselves by saying the PD can't spend any city funds with regard to those activities, that could be problematic.
Okay. Any more questions on this?
I mean, I have more questions, but I don't know that I'm still
Relative to-
formulating questions about it.
Oh, you wanna, you wanna ask him more right now, or you wanna wait?
No, I'm saying I'm just saying this is a lot of information to take in
No.
kind of all at once, so I just want to reserve the right to ask more questions at a later time.
Hey, no problem.
Yeah,
The only
that's
other
what
thing
I
I
mean,
have
yeah.
on here talks about the issue about enforcement priorities. And my concern about enforcement priorities is, since I've been here, our police chiefs have always been reluctant to direct their subordinates to either enforce or not enforce certain laws. That's a problem for council. It really is a separation of powers issue. When I first started thinking about this, I started thinking about it from the perspective of executive orders, but executive orders come from the president, and the president is the head of the executive branch, and it's going to his subordinates with regard to enforcement priorities. And Congress doesn't have that same ability. For example, if you think about the issue about marijuana is still a violation of federal law, but there's an executive order that tells federal law enforcement agencies that's a low priority. We're really not going to go after people that are just simple possession. If Congress were to do that, they would be infringing upon the president's authority as the executive. And Congress's remedy, if they thought that they didn't want those to be enforced, is to repeal that statute. The issue within this resolution with regard to directing the police department to make abortion-related crimes a low priority enforcement has that same separation of powers problem. It also has issues under Article 3 of our charter, because under Article 3, council members can't direct subordinates of the city manager to do or not do something. And if council is telling police officers to make this a low priority, it would appear to be a violation of Article 3, Section 6. The other thing that I looked at was the issue about HIPAA privacy rules. And that's kind of sort of what I was talking about earlier. Under HIPAA privacy rules, in terms, for example, if a state statute says a healthcare provider is required to disclose certain information, HIPAA, which would supersede that state law, says that disclosure by that healthcare provider is discretionary. The same is true for disclosing information for law enforcement purposes. If a law enforcement officer went to some healthcare provider and said, give me this healthcare information about your patient, whether or not that person complied with that directive is discretionary under HIPAA. And again, a lot of that has to do with whether or not you have the consent of your patient. Disclosures to avert a serious threat of health or safety, again, even that disclosure by a healthcare provider under HIPAA is discretionary. And more likely than not, most of our healthcare providers, I'm sure their legal counsel is telling them you need to exercise your discretion in favor of not disclosing it, because you don't have to. And that potentially puts you in jeopardy. On this particular website, you can submit complaints with regard to alleged violations to the Department of Health, and however that federal department is titled. But most of the time that I'm trying to get information from a healthcare provider, unless I've got, even if I just send you a subpoena, they're also going to want a health records release. They're just not going to submit it just as a subpoena. They're going to want a medical release. So some of this is resolved by HIPAA. I do know that I did see just before I came in here, the former Attorney General had written a document to law enforcement entities about enforcement of this. And one of the things it talked about really heavily is this is really aimed at the medical care providers and not the patients. And again, I don't know of any instances where somebody's either been charged criminally with violation of those provisions, or even if a civil case has actually been filed under that statute that allows private entities to sue people civilly. So, yeah, that second part is a little bit more problematic in my opinion, just because of the fact that I know historically we've been reluctant to tell officers what to enforce and what not to enforce. And again, that directive coming from council has issues with regard to separation of powers and also has issues with regard to the charter provision.
If you're waiting on me to look at you and you got a question,
I
just
am.
talk. I'm not, y'all are adults. Y'all just ask questions.
Okay, well, I mean, this is the way that the law is.
I know, but that's what I'm telling you, just
Okay.
rock and roll.
All right, so in regards to the charter, potential charter violation to, a council member saying that you shall do this or that, I'm just trying to understand, are there any policies now, because we're a policy body, so we're enacting policy, so we're not necessarily going as a council member to the chief of police and say, don't do this. So are there other policies that we have that dictate the way that staff does their job that council has passed?
I mean, you can set policies regarding the standard to be used. I mean, think about engineering design criteria or things along those lines. You're really setting the standard. And then
Okay.
staff is going out and enforcing the standard as you have set. The difficulty with this particular issue is we don't set the standard regarding abortion issues.
Okay.
The state does. And we're trying to circumvent what the state does by directing law enforcement to make this a low priority. And that's what potentially runs afoul of Article 3, Section 6. It sort of has its genesis in the fact that we don't have policymaking authority in that particular area to begin with.
Okay, so in another angle, the city manager is dictating policy, I guess, for staff. So could something like this come down? I'm not saying that he will do this, and we can't dictate that he does, but would the city manager have the capacity to create a policy like this and ask his staff to adhere to that?
Yes.
Okay.
My-
So
my
really
own-
at the discretion of the
yeah,
city
my only
manager.
caveat is,
You probably would not advise him to do that, I understand, but I'm saying he has the ability to
Right.
do that.
we talked about this even from the issue of, well, what's the enforcement mechanism? Because if, let's say the city manager directed the police chief to establish a policy that says this is a priority and some officer violates that policy, he's a union member, he's going to be entitled to grievance arbitration. And when we have grievance arbitration and we get to an arbitrator, is the arbitrator going to come down on our side or come down on the side of the management or the employee? The employee saying, look, this is what state law says. And all I was doing was enforcing state law. And how can I be disciplined for enforcing state law, which arguably is statewide public policy? Notwithstanding the fact that we may or may not like it, essentially the
Well, I think,
legislature has the ability to establish policy in those areas statewide, and we're kind of circumventing that and then disciplining you because you didn't comply with we didn't comply with our alleged attempts to circumvent what the legislature has said is state policy.
yeah, I'm just trying to understand the nuance in not making it a priority, because I don't think that means that it will never happen, but that it is, other things should happen first.
And maybe the issue is there needs
So,
to be clarity on the issue of what does it mean to not make it a priority.
okay, so then we can talk about language regarded to, and definitions regarded to not making it a priority, so we have more things that we can potentially discuss
Yes,
in this area. So I would say that, we're still learning about,
I think that, yeah.
the law and how this relates. It's new, it's evolving. And so I think we need to continue to turn over all of our, I guess, leaves. Rocks, whatever you want to say.
Well,
I don't know, I think there's some nuance here that we might be able to get to something that helps protect citizens in this regard, but that also doesn't go against, state law or something that could put us in jeopardy.
it would seem to also open up a gate, if we did do that, to open up a gate that we could actually interfere in any process that was done through the city manager by staff. If we decided that a driveway needed to be paved instead of something else. And it just if we do this, abridge this one time, we've kind of perforated the whole idea.
Well, I had discussions yesterday with the deputy chief and a couple of our management level employees over there, and the word that they used was slippery slope. The question becomes, especially on the issue of enforcement priorities, because, you know, the question from the officer's perspective is, okay, where does the line stop? If you can tell me to not make this a priority, well, what else can you tell me to not make a priority? And how do I go about doing my job, trying to understand, well, this is a priority, but this isn't, or isn't a priority in this occasion, but not in this occasion? And I think what the focus of a lot of this is to remember is, the focus isn't on the person either obtaining or seeking abortion. The focus is on the healthcare provider.
I mean, isn't everything that we do a slippery slope into the next policy that we could enact? I mean, really?
Sometimes yes, sometimes no. I think it depends. And one of the things just learning is slippery slope fallacy can sometimes be a legitimate argument. That, yeah, it is legitimate. But again, you know, kind of sort of talking through it with them, that's some of the concerns that they were raising with regard to this particular issue.
Anybody else? We good? All right, where are you at over there? Are you doing this next part too? Who's on the next part?
What's the next part?
Yeah, warming shelter update.
I don't know who's supposed to provide that.
All right.
I would think it would
I
be
did, that was a new one, or was it, which one was,
So,
okay.
so
Yeah.
I asked for that to be added because we used to get updates on the warming shelter that we operated, and now we've appropriated money to an entity to conduct and run an emergency shelter through a certain number of months. And so really I wanted it agendized, even if we didn't have anything, to ask that we get reports from our contracted provider for
I've had
that.
some emails where Gerald has asked for that.
I definitely would like to know what's going on there.
Yeah.
Numbers and things like we used to get.
If there's been any, I've heard any major problems or anything out of the, I guess,
Yeah, how is it going? What are the numbers?
What are
Kind
the
of
trends?
trends,
Because
yeah.
like the valuable information I get from that is spikes in populations, whether they're young, old, veteran, whatever.
Yeah, and also understanding too, like, what happened in December with our deep freeze and how did that affect operations and staffing and all of those kinds of things. So like just understanding those nuances.
I know he sent over the format of the previous reports we did for him to follow. I just don't know
Yeah.
what the status is.
Perfect.
Did y'all have any of these cases that y'all wanted to bring to executive session? We didn't.
I mean, to me, if staff thinks
And
that
as
we need to have
movement.
it, then, or if staff needs feedback from us,
We
yeah.
do come to you guys if we get to a decision point in a case, settlement offer, jury trial or not, mediation, those kind of things will come to you every time with that kind of stuff.
There's some on here that even hanging out old that we could at least, that they don't even know about. I mean, I don't know if they're still tracking. What was on the FOP ones and the IAF asked me those two on the front page of this? 11 and 2011 and 2005.
Yes,
And if that's something we can talk about in executive session either and get rid of it. I mean, that's what I want. When we have this, we have people that ask us, how many suits is the city in? I don't know. There's a whole bunch of them that are just sitting there. And when you print out this piece of paper, if we can make that piece of paper smaller, because we can just get rid of some of these that are just hanging there.
Sometimes we're on the slow end and we don't want to press them to
Yeah,
finalize.
blame me. Yeah, you're, and that's all you have to say. I understand that for sure. I will slow roll something if it needs to, because sometimes it resolves itself by the end of that anyhow, so. But I do have some if you want to make a list. I think I got 4. Just that interested me, and one of them was not one we talked about today, but it was one I've been hit up about a whole lot, and if we can discuss it, I'd like to discuss it. It is Levi Wilkins versus City of Norman. That is
That's a workers' comp case.
Yeah, can we talk about that one? Okay. That one I want for sure, and then that Thompson versus City of Norman et al. That's in the,
More
Wait a second, wait a second.
was that the vernacular, no, which one?
No, that was the hospital gentleman who
Oh, yeah, that one's because some of that has gone over and I've never heard about it. I want to know.
Were you here when we did the executive session for the settlement offer that they made? You may not have been.
I don't think so. That's why I'm saying, I don't know. I know of that one, but I don't know any details of it. So that one I would like to take a peek at. And that's kind of my only curiosity, my self-curiosity, to see where it's at, because I don't know any details of what's happened in it.
Come by and I'll
Okay, well, I'm just saying, if that was one that, if you just want to fill me in, just because I don't know, and I know we can't talk in
Yeah.
this or whatever, and,
always call us if you have a question.
yeah, well, that one I did.
Yeah.
Like I said, I didn't know even what some of these existed. And then, let's look at these two, the 2011, 2005 FOP Act.
Here's
one.
the 2005 FOP is, at some point in time, during this negotiating year,
steroid scandal.
yeah, during this negotiating year,
That's around that time.
we,
2005.
it has something to do with, I think, the raising of health insurance premiums. And ultimately, FOP, IFF, and ASME took the position that we couldn't. We took the position that we could. When we took the position that we could, the next argument was that we needed to solicit wage deduction forms to every employee to authorize us to deduct those healthcare premiums from their wages. We did that, and the unions pitched a fit and said, you can't do that. So they sued us and the Department of Labor, because the Department of Labor came down on our side to say, yes, before you deduct amounts from your employees' wages, you need to solicit a wage deduction form from them. The labor unions were taking the position that no, once we agree to a certain premium in the collective bargaining agreement, that authorizes you to deduct wages from.
So this is something stupid?
Right, so-
But can we get it fixed with a piece of paper pretty much, or something?
That
I mean,
arguably-
it's hanging out there that long, how does it not had any,
Arguably, that case is probably moot because we're well
Yeah, that's-
beyond that many.
that's like this, if there's any of these, like, we have a list.
Right.
And I know that it takes time and resources and you have tons of other stuff to do, but if we can just dwindle down this list of things that have just, are waste, nobody's ever gonna do anything on again, that would be awesome. Just because of this list, because this is the first time I've been asked for this and I thought, oh, hey, why don't we actually do that? And I didn't know how big, I appreciate y'all, I don't know how big of a pain in the butt this was for you, but it is appreciated and it's probably good as oversight to see how many suits do we have against us right now? How can we take care of some of these? And I know that y'all do your work, and you do bring it to us, but
But even maybe the more important piece of it is what we provide with the audit report, which I think you all will get with your final audit, and that's our exposure.
okay.
So we do that every fall when the auditors are around and trying to ascertain what possible exposure we have.
And if y'all have some more ideas, like this just kind of came to me like, hey, we ought to probably do that. That's probably a responsible thing to do. And if y'all have some ideas of like looking at this stuff that's not our normal thing, I mean, this comes to us, but to have this whole list is something that I was always kind of like, I knew that we had talked about it, like, we don't even know how many people are suing us right now, and because I get asked
I thought it
all
would
the
be more
time.
actually. So.
Yeah, it's pretty profound.
I mean, it's gonna happen, what are you gonna do?
Rick, I have a solution for Shaz, if anybody ever wants a solution for that.
Okay.
Executive session, I guess.
Yeah.
2011 FOP case is about whether or not holiday pay is considered to be regular wages for the purpose of pension contribution.
Oh,
In that case is, I mean,
That's a good
part of it
question.
is, do I really want to shake that
You wanna what?
shake that bush or not?
Oh, yeah, okay, I mean, that's fine, but like I said, come in and give those few to all of us and at least we know and you say go along and we'll be done. I think most of those were not, that one of them might be real complicated. Sound like those two are gonna take about 2 minutes apiece at most, maybe with a couple questions. And then you figure out whatever you wanna do or whatever direction, and then, some of these that other one might be hairier, just whatever you feel on that. If it's super hairy and it's not there yet, don't do it, but that one's kinda, if you want me to just come get information from you, I'll do that too.
I'll do that.
Okay. But the other one I do wanna talk about, just because there's so many people who said, hey, what is happening in this case? And I was like, I don't know, I'll see if we.
He's outside counsel on that workers' comp case, and he can come in.
Okay. So that's, all right, we're there. Any other further questions? Anything? Good meeting, thank you, appreciate it, adjourned.